Good afternoon, everybody. Welcome to this first of the two plenary sessions of our Common Core meeting. We're using a slightly different format than the years before. Therefore, we have been together now quite a bit. The fundamental idea of this meeting was not really to create two separate groups, one of people dealing with property and one of people dealing with tort, but rather the idea was the opposite, and was to try to discuss once more the fundamental categories of private law, in particular from the perspective of a phenomenon that, talking with some colleagues and talking between me and Mauro and picking up the topic of this year's Common Core, we thought could be a sort of transformation. The hypothesis was that the death of contract, to use a very famous title of Grant Gilmore, the idea that the consent, the idea that the ex ante organization of legal transactions based on agreement is declining in favor of some sort of a next post situation, and is yielding to, so contracts are yielding on the one hand to property relations and on the other hand to tort relationships. So we're kind of boiling down to two broad ideas. One would be the idea of property that we see expanding with the technological frontier, in which the relationships are relationships of, so to say, comparative might, formalized by legal categories such as those of property. In fact, would be almost a kind of growth of possession, a growth of de facto relationship on the frontier of the internet on the one hand, and on the other hand, the fact that ex post remedies, such as tort remedies, are actually becoming the only one that looks like still in the hands of lawyers. So contracts, in a way, losing some of their traction in front of these two other categories. The expansion of property law is actually basically the topic of this first plenary, and therefore we've been selecting our speakers with in mind their scholarly interests. On the one hand, we have Antonio, which everybody of the Common Core knows. He was with us since the very first edition 26 years ago, and he's been the chair of the property group for a long period of time. Antonio is perhaps the most distinguished and theoretically advanced scholar of property law in Italy by large, and possibly in Europe, and therefore he will have the kind of theoretical insight in our discussion that we really badly need, especially in front of transformations that are very quick and fast. We need some, so to say, the foundations clear, and so we have Antonio discussing that. Then we have Anna Robilant. Anna is a professor of private law and comparative law at Boston University. She graduated in Torino. She did a PhD actually at Harvard, and I think also one here in Trento. Yeah, because I was not sure whether it was in Torino or in Trento, so great. It's here in Trento, and then she's now active in the United States, where she's been establishing herself as a scholar of property law, especially of the social impact of the law of property. She's been dealing with the commons. She's been dealing with issues of gentrification, a lot of areas, but she has been engaged in writing a book on property law, a comparative book on property law that is now, I think, in a very advanced stage, which is on the Romano-bourgeois roots of modern property, and she will, of course, address it from an historical perspective. How much of these roots are still valid today? How are there still ways in which we regard at legal issues? So that's why we thought that Anna would have been a fantastic speaker for this morning. And then there is my colleague and friend Radhika Rao at UC Hastings. Radhika has been also a scholar of property for a long period of time. Her first article was called Privacy and Property, back a few years ago, quite a long time ago, not as long as the Common Core, but quite a long time ago. And actually, I remember very well when she was a very junior faculty member, we were discussing this issue of the boundaries of privacy and property, and how property categories and vision could be transferred to more personal privacy matters. And Radhika has been doing really, really interesting work in the expansion of property. Basically, all around her scholarly activity, she's been applying property ideas to different areas, further and further away from the core of the economic relationships of property law. So we thought that if we were talking about how property expands and property reasoning expands, and how, you know, it basically imposes its value or non-values to a variety of human transactions, she would be a very good speaker to do that. And finally, Cristina. Cristina is a current student of mine in the PhD program in Torino, after having been graduating in the International University College, which is one of the institutions that has been organizing the Common Core in the last few years. Cristina is a South African lawyer. She's been working also on property and a variety of matters, and she participated in a kind of call for younger commentators that we decided to make for this year, in order to have a discussant that asks questions and sees, you know, the presentations in the perspective of someone who is growing as a scholar in this present stage. So we have a really, really rich panel, which I very much look forward to hear, both from a personal perspective. Antonio is my mentor, Anna was my student, Radhika is my friend. I mean, it's a very personal way to celebrate the 25 years of the Common Core. So without further ado, I certainly give the floor to Antonio. Thank you very much all for being here. Thank you.
Thank you, Ugo. But I think that my position here depends by the privilege of the age. That is quite a sinister privilege. But anyway, it seems to me that the Common Core project on property law has to some way turned his attention from an analytical point of view to a critical point of view. But to some extent, it's true that comparative law is always critical, because comparative law is useful to make clear what is... So it's better? Okay. What is not at the surface of the legal system. Nevertheless, I have to make some remarks. What is being discussed from a critical point of view are two different topics. One, the narrative of the idea of property law, and second, the structure and function of property rights, and more specifically of property right that derive from the position of private property. So I will speak only on the second topics. And further, I will focus my attention to the real property, pointing out, first of all, that real property is local in nature, but strange enough, talks regarding real property looks to have a universal content, a discrepancy that we have to solve in some way. But I want to overlook all terminology issue, but I want to insist on the necessity to clarify previously what is the object of property right to which we refer, because without any reference to the object, all discourses regarding property rights are too abstract and empty. So, first, I will devote my attention only to the property of durable material things. And in this regard, you probably know what is my thesis that has been presented in a brief treatise a few years ago in Trattato Iudicazzati, La Proprietà. Is only in Italian, but I have good news. is in the way to be translated into Chinese. So the people who are not so familiar with Italian can have an easier way to read it. Regarding durable material things, I think that we have to introduce a main distinction. Those durable material things that, if they are left without human care, are destroyed. Are destroyed because nature destroyed it. It's part of the ecological circle. And those objects that, even without human care, are preserved, in the sense that they continue their way of being, if they do not suffer injuries from outside. But I will not speak about earthquakes and typhoons, etc. So, things that are durable but are preserved without human care, and things that without human care are destroyed. In my mind, a legal system is justified when it proceeds to attribute ownership to individual or groups or family, etc., on durable material things of the first type. With respect to durable material things of the second type, protection is justified, but not is justified attribution to a single ownership position. There is no need to have an owner of the river, there is no need to have an owner of the forest. In this framework, a particular place, from a historical point of view, is occupied by the durable material thing par excellence, that is the land. And this regard, there is a problem of language. A problem of language that is difficult to solve, but I will skip it. Because land is too generic attribution to things. So I will speak only of land for agricultural purposes, and leaving aside waters, mine, buildings, and other structure, that different legal arrangements are required. The reason of this reduction is that the land ownership for agricultural purpose has been at the center of intellectual debate on property for centuries. And if you look to the legal literature and also to the philosophical thought, when philosophers, jurists, political scientists speak about land, they speak normally about land for agricultural purpose, because this is central for the construction of the political arrangement in the society. From a point of view of analysis, however, we have to distinguish between land and estate in land. Indeed, the word estate in English is not exactly the meaning that I want to emphasize. It's better to use the German word Grundstück. Grundstück indeed is the German translation of old Roman idea of fundus. And as probably you know, the idea of fundus has been shaped not only by the jurists but by the grammatici veteri, who are part of the digest. But I skip also this type of problem. What I want to emphasize is that the idea of Grundstück, fundus, estate designate not a material things, but a semi-material things. Von Baer speak of quasi-legal things. Quasi-legal things, that is to say that it denotes a segment of land, but a land that is being geometrized, confined, and qualified by legal rules. In summary, we can speak about fundus not only in regard to a slice of land, but as a cultural product, because a fundus exists ontologically when it is measured, confined, is subject to a specific legal regime and possibly registered. Obviously, this meaning is a product of history and a long-term history. It can be originated in the Neolithic Revolution with the introduction of the farming technique instead of hunting and gathering techniques. But even this aspect I will leave aside because it's too much complicated to report. But behind this historical story, the meaning of the word Grundstück lies in the choice of institutional strategy that can easily be retracing in the need of an agricultural society. An agricultural society requires that a fundus will be given to someone in a kind of exclusivity. But here the word exclusivity has a different meaning, because property is always exclusive, but it depends by the object. In a hunter and gathering society, exclusivity of property was practically meaningless because the object of exclusivity were the food prepared for cooking, the equipment for hunting activities that were really minimal, and so on. So it was not a problem. The problem arises when there is a fundus cultivatus. In that case, exclusivity is a problem because it is a very strong form of exclusivity in space and time. I mentioned that exclusivity in space has been at the center of attention of century-long reflection. But I want to focus about exclusivity in time, because the land of ownership is conceived nowadays as exclusivity for an eternal space of time. It never ends. Is that true? What is the rationale of exclusivity given to someone for eternity, for no limit in time? Let me return to the idea of exclusivity. I think that if we look to the long history of agricultural society, and of course in a comparative with a comparative approach, we soon discover that exclusivity has two implications. The first of structural nature, the second of finalistic nature. In fact, exclusivity implies that attribution in appertainance to someone, individual, family, organized human group, whatsoever. Here, the subject aspect is left open. But it's considered a choice of institutional strategy, that is to say, a collective political choice. A collective political choice because the legal system wants to attribute an asset to someone in exclusivity, pursuing a political aim. So the political aim is to give, in our case, a piece of land, a plot, to the people who are in the better position to take care of it. So the aim is to allocate the resources in a more efficient way, giving what we call ownership, but take the words in a very large sense, to the people who is in the better position to exploit the plot in the better manner. This is the aims of the attribution. If this is the aim of the attribution, and we consider that the attribution is based in a collective political choice, period, paying attention that in all the literature that we can read, this is not the rationale of the attribution. Normally is the supranational will of God. The attribution is given by God, and so you can dispute it. Or is part of the law of nature. Is the law of nature that provides that some plot of land can be attributed to someone and attributed forever. In the Lockean rationale of private property, this is the result. You work on the land, you acquire title on the land is yours forever, and nobody can take the ownership of the property right back. If this is the issue, then the second question is this. It's true that if we take as an assumption that attribution of land ownership is the product of a collective political choice, there is no need of some mechanism of surveillance, because during the time it can happen that the people in charge to take care about the land, but if we think about the channel, the temple, etc., the result is exactly the same. The people who at the beginning was suitable for taking care of the plot of land is no longer suitable. This can happen during the time. This, of course, is part of the life. Also because if we think about a physical person, normally physical person died before the destruction of the land. You know that the destruction of the land will happen, but in 200 billion years. So normally people does not survive for such a long time. So there is a problem of a mechanism of surveillance. And in the dimension of time, it seems to me that this is the main issue regarding the attribution of property, of ownership. And the point is, as the political community the power to withdraw the initial attribution, if we look to the legal literature, it seems to me that this has been the point that has been more discussed, but discussed in a disguised way. Indeed, what is discussed in legal literature or in philosophical approach or in political thought are the dogma that stay behind the idea that the attribution of ownership, even on land, can be withdrawn. If we take seriously the idea that attribution has been given to someone because it is, or it was, considered to be the best people in order to take care of the thing, the land in my discourse, but I repeat that it can be the same for the channel, the temple, the building, etc. Then this means that if that people or his or her successor take care of the thing, the title is untouchable. You can withdraw the title. But if the risk that the thing can be disintegrated by the force of nature, then the title can be withdrawn. To some way, it seems that this approach is not different from the classical Chinese theory about sovereignty. You know that the classical Chinese theory about sovereignty was of this kind. The sovereign has been created normally by God or supernatural intervention, but in order to take care of the people and of the well-being of the people. Normally this means to take care of the channels, the distribution of water, the road, etc. If the sovereign fail to fulfill this task, then it is to be the legitimate sovereign. To some other extent, this idea can be translated into a Romanistic term to say that attribution of property will have some feature of the idea of officium in Latin term. Officium indeed is not a property, is the contrary, is a position of duty in which the people that is entitled of the officium must take care of something. And if it does not, the officium ceases to be the legitimate, that can be revoked. I know that from a realistic point of view, the idea to disinvesting the holder of an officium of a sovereignty is been a very complicated task, normally bring to violence and civil war. But anyway, from a theoretical point of view, this is a possible coherent approach. Again, if we look to the history, we can say, and here I make a reference to an article by Stefano Rodotà, not a very new article, it has been printed in 1979, regarding the definition of property rights in the Napoleonic Code, in which Stefano was making reference to the discussion during the preparation of the French Constitution in the time of Revolution, making clear that the idea of the possibility to withdraw the title of ownership on land or on durable real property was central during the debate. During that debate, the discussion has taken the color of politics. So from that time, we start to think that a left-wing orientation brings to the idea that property can be taken if the owner does not fulfill his task. And the right-wing orientation has been, no, property is sacred and inviolable. It cannot be revoked because the owner is owner by the law of nature or by the law of God, not by the law of man. Into brackets. In reality, when the problem come on the table and become a real issue, normally left and right are perfectly in agreement, for instance, to take away the church property. And so the debate was totally ideological. But nevertheless, to me, it's important to resume this millenary debate in order to underline one aspect of the structure of property. The structure of property requires a strong temporal dimension. If we look to the idea of ownership, of full ownership in the Western legal categories, we immediately conceive that ownership is limited in extension, in geometric extension, but is not limited in temporal extension. And looking back to the history, we normally think that the idea of taking care of, I come back to the original object of my discourse, agricultural plot, take care of it, means that you must cultivate it. More or less that was the problem. So ownership can be revoked only if someone does not perform the agricultural activity that is required for that piece of land. And that's been also the same. During the conquest of America, land has been taken from the original settler because they were not engaged in agricultural activities, and given to people who were engaged in agricultural activity. That was the rationale of the agricultural history of the United States, Canada, and even Southern and Central America. But it is still so, because there is a last remark, obvious remark, that I want to make. If we look at the philosophical, political, legal literature and tradition, we go back for millennia. And we have an immense body of literature. By the way, suggestion, if you want to write down a treatise in 3 volumes, quickly take these topics and make a summary of all the literature that has been already printed, and you reach your goal in 3 months or 6 months. That can be a good way to take a university position. But in that literature, there is something that is missed, totally missed. The philosopher and the political scientist has always missed to take care of notes, or the problem of externalities. Externalities, especially negative externalities, are never considered. They are not part of the problem. And probably they were right, because in a pre-industrial society, the problem was practically inexistent. But nowadays, when we say that, okay, I give you this plot of land for agricultural purposes, to cultivate it is enough to say that you have taken the proper care of the thing that has been attributed to you. Normally we say that nowadays no, because we have to take care about externalities. All the discourses regarding environment, climate change, etc., are discourses or dispute regarding externalities. And externality is a symptom of imbalance in the allocation of resources. Given exclusive appertenance position to someone, and say that is under, anyway, some type of exam, I want to know from time to time if you have performed well your task. Your officium has been performed properly. Then is possible to say that, okay, your agricultural activity has been performed well from the point of view of grain production, but not from the point of view of the preservation of the environment. It will be enough to justify that the title of ownership will be redistributed. I think that if we look to the structural property in this way, we have an analytical tool in order to discuss about some problems that today are hot problems in a more analytical and scientific way. And this is obvious, but is the only thing that I can suggest. Thank you for your attention.
Thanks so much, Antonio. This is basically a very central issue of justifying exclusion, and the fact that exclusion is not justified per se, and the fact that lawyers even think about this kind of stuff is kind of new, because in the traditional way in which lawyers look at property law, every issue of distribution and every issue of legitimacy of ownership are just taken for granted. Are just considered constituted problems. Whereas property has been going through a lot of transformations, and there are constitutional moments, revolutionary moments, even in non-explicit way that happen because of all sorts of changes around us. And of course, one of those moments, perhaps the most important one, whose consequences we are still facing, was the moment in which modernity decided that there was an excess of commons and there was not enough capital, and there was a necessity of transformation of use value into exchange value. And that is basically the origins of the modern structure of property law, what Anna calls the bourgeois Roman structure of property law, and also of most of the other institutions of private law as we know them today. The general theory of contract was born in a moment in which it became clear that it was desirable to transfer property to someone who is valuing it more than the other one. So the idea of the general transfer of property came out there, and even the idea of tort law as a based on fault was also part of the same strategy of trying to incentivize the development of exchange value in society. So incentivizing people to take risks, to invest, and to transform commons into capital, basically being certain and shielded by rules of fault, for instance. So this whole moment was between the 17th, 18th century, and has been a moment in which that our institutions were framed, and we're still living on those kind of institutions, in a moment in which many of the conditions, the surrounding conditions, are radically changed. As Antonio was saying before, we were in the early phase, in pre-modern times, in pre-industrial society, the issue of externality was just not there. There was such an abundance of common resources that we could simply try to make as much private property as possible, because that was desirable per se to accumulate some of the capital that then was necessary for the development of modern institutions. Today we are exactly in the opposite conditions. We have too much capital. We have an amount of capital that is inordinate, and we don't even know how much we have. And we have every single use and common in decline, blinking red, saying, okay, but we still have the same incentive structures. We still have laws that incentivize making more commons into capital and going in the usual direction. And so we really kind of need to think about how to handle institutions, so to incentivize society to take a proper turn. And it seems to me that this is really pretty much an interesting moment to study property. But of course, to study the future, we need to have the roots in the past, and we had them with Antonio, who went all the way back to the establishment of the agricultural society. And now it is a great pleasure to hear Anna, that will talk about what I consider the most crucial moment of the making of the current unsustainable model of private law, which was the years around the French Revolution, I guess. Anna, you have the floor. Thank you so much.
Thank you so much. Can you hear me? Okay. I want to start by thanking Ugo and Mauro for inviting me and for 25 years of wonderful, robust conversations about private law and property in particular. I also want to thank our hosts, our gracious and generous hosts, Professor Luisa Antonioli and Professor Andrea Pradi. And finally, I want to thank Giorgia Sartori, who, with great patience, and competence, organized all the details and travel arrangements. Thank you so much. So today, I would like to discuss an idea that, to those of you who have done more sort of destructive work in property law, may sound provocative. And that is the idea that what I call, it's a term that I borrow from Aldo Schiavone and many others, the Romanist bourgeois property culture, which has served so well the needs of liberal industrial capitalism, and then the needs of the sort of networked information capitalism, thereby contributing to the current crisis of inequality and sustainability. A property culture that has also significantly limited our institutional imagination. Well, this very property culture also offers more neglected and overlooked ideas that may be part of the way forward today. And what I have in mind is specifically the idea of resources, a resource-specific approach to property analysis. So in my 20 minutes today, I will start by backing up a little bit, and I will discuss what I see as being the two widely known building blocks of Romanist bourgeois property, dominium, modern dominium, and the social function of property, two pillars that coexisted uneasily for over 2 centuries, and it proved extremely pervasive. And I will then elaborate briefly on the resource-specific analytical lens that I have in mind. So the two fundamental pillars of the Romanist bourgeois property culture I see as being modern dominium and the social function of property. Modern dominium, which was basically invented over the course of the 19th century by the liberal jurists in continental Europe and in Latin America. The idea was that modern dominium, absolute and exclusive, was designed along the lines of its historical predecessor, Roman dominium, dominium ex iure quiritium. But given the research that Romanists have done in recent years, we know that actually the significance of Roman dominium was more symbolic than practical. Roman dominium, yes, had all sorts of ritual and formalism that spoke to the idea of absoluteness and exclusivity. The procedure of limitatio, which marked the boundary of the parcel of land, effectively defining many coexisting spheres of absolute will. The transfer through mancipatio, another highly formalistic and ritualistic element. The fact that Roman dominium, to signify its absoluteness, was exempt from real estate taxes. But this was all symbolism. Practically, Roman dominium belonged to a very small percentage of the population, Roman citizens, and accounted for a very small percentage of land, right? Large swaths of land in Italy were actually owned by the state as ager publicus, and land in the provinces was owned by the state with different types of modes of ownership. So basically, dominium, highly symbolical, coexisted with these alongside these other more limited modes of owning. So really modern dominion was an invention, or at best, a creative retrieval. A creative retrieval that had, for the 19th century jurists, a number of crucial characteristics. So the idea that Roman dominion was an exclusive and immediate relationship between the owner and a thing. An exclusive and immediate relationship structured as a very tightly packaged set of entitlements, of absolute entitlements that gave the owner broad control over a thing or resource. A tightly packed aggregate that included the right to destroy, the jus abutendi, as an affirmation of this absolutistic power. Today we are talking about the jus abutendi again, the right to destroy, but in very different terms, as a way to protect privacy or to achieve efficiency, not as a mere affirmation of absolutistic ownership. This modern Romanist dominion that was supposed to be broad in space, reaching down to hell and up to heaven, and perpetual in time. And it also seemed insensitive to social context and resource time. So this modern Romanist bourgeois dominion was obviously purely aspirational and largely unworkable. Why was it so successful? Why did it pervade 2 centuries of property thought the way it did? Well, the conventional wisdom is that, from Weber to Perry Anderson, is that it served very well the needs of capitalism, paving the way for capitalism. Now, there's no doubt that over the long term, modern dominion facilitated the advent of capitalism. The transition from feudalism to capitalism was really, in terms of property structures, the transition from divided dominion to modern absolute dominion. Divided dominion, where a superior owner would extract surplus value from an inferior owner who was tied to the land and bound to the lord, largely through extra economic coercion, to modern absolute dominion, where owners of the means of production, strong of their absolute dominion and property rights, would extract surplus value from the direct producers, free wage laborers with no landless laborers, through purely economic coercion. So there's no doubt that capitalism did play a role here. However, we know that the connection between property and the advent of capitalism is less direct, slower and less direct, right? It is long-term. It is long-term. In France, the new idea of dominion is really the idea of the code, 1804. But actually, full-blown capitalism doesn't develop in France until late in the 19th century or even the beginning of the 20th century. In Germany, the Stein-Hardenberg reforms that were supposed to kick in a broader property reform are the beginning of the 19th century, but actually full-blown capitalism only arrives towards the end of the century with the Bismarckian revolution from above. So the connection between property and capitalism is less direct. The transition to capitalism was also in large part the consequence of class relations, the nature of the state, the absolute state, the different variants of the absolute state, the development of internal markets, the pressure of the international capitalist world system. So if that's the case, if the connection with capitalism is more tenuous than we usually assume, why was this purely aspirational idea of dominion so pervasive and successful? Well, it was a powerful ideological weapon because it really spoke, it resonated to several very different audiences in the public opinion, in the educated public opinion of the early 19th century. It spoke to a long natural law tradition that dated back to Gratian, Occam, the Second Scholastic, and then Kant. But it also spoke to the new political economy that was developing in Europe at the time. The physiocrats, the cameralists in the German-speaking world, or the various societies of agronomists, all of which emphasize the link between robust absolute property and improvement and growth in productivity. And finally, it also spoke, surprisingly, it also spoke to a sort of more liberal, egalitarian, post-revolutionary tradition that Pierre Rosanvallon, in his recent book, describes as the society of equals. And here the idea was that robust ownership, robust dominion, was the path towards a society of equal citizens and equally autonomous full owners. Of course, this more liberal and egalitarian tradition turned a blind eye to the fact that absolute dominion would, in turn, lead to inequality and to new oligarchies of wealth and power. They turned a blind eye and they minimized the risk of inequality by noting, for example, that the fluidity of the market would periodically redistribute property, by noting that the exercise of virtue and moderation would also help in mitigating inequality, and that fraternity and a social ethos would mitigate inequality. But really, I think the key to the success of dominion was the sort of the fact that it was appealing to a wide variety of audiences. The second building block, well known in the Romanist bourgeois property tradition, is the idea of social function. As the end of the 19th century approached, a group of critics of with very different ideological perspectives, some that we would call robust liberals, some that we would call solidarists, some that were effectively utopian socialists, started launching an attack on Roman dominion, on Roman absolute dominion. They were largely concerned with the negative externalities that resulted from absolute dominion. They were also concerned with expanding access to productive resources in the interest of growth and productivity. And then there were also some radicals interested in larger and more radical distributive agendas. These critics attack Roman dominion as descriptively inaccurate, normatively undesirable, and developed a new set of ideas, again, largely based in Roman law about property. The idea that property has a social function, has or is a social function that requires regulating and limiting entitlements to protect the interests of others, neighbors, and the public. They retrieved the idea of dominium divisum, shedding all the negative connotations that it had acquired in post-revolutionary times, at the time of the big anti-feudal, very vocal anti-feudal rhetoric. They saw dominium divisum as a useful analytical tool that shows that property is relational, is intimately relational. And some forms of dominium divisum, such as emphytesis, were also considered important policy tools to expand access. They discuss at length the prohibition of abuse of rights. And they also retrieve the lex agraria, the Roman lex agraria, the Gracchian lex agraria, that in the 1790s in France had generated so much fear and anxiety and so much angst for German scholars, Romanists such as Niebuhr. Well, the lex agraria was retrieved as an actually workable blueprint for land reform. Despite the virulence of their attack, the social critics never managed to oust Roman dominion. If anything, they ended up further entrenching the idea of absolute dominion because they made it workable. They made it more realistic and more workable. So these are the two well-known pillars. What is the third sort of overlooked and neglected pillar in Romanist bourgeois property? Well, it's the resource-specific approach. Resource-specific approach, the idea that property is ultimately and intimately about things, about valued resources. That things, resources, have different characteristics, implicate different values, different interests, and that property ownership entitlements should be shaped and limited and packaged to best promote these values and interests implicated by different resources. This is an idea that is unique to us, that is unique to the continental tradition, to the Roman law world. The Anglo-American tradition has a good equivalent of dominion, Blackstonian property. The Anglo-American tradition has many of the ideas that we got through the social function, Hofeldt and the realists. But the resource-specific property lens is largely absent, has been largely absent until very recently in the Anglo-American tradition. So that's really unique to us. And it's an analytical lens that we owe to the Roman jurists. The law of things developed a very detailed and in a way formalistic taxonomy of things, classification of things, the various things that can be the object of ownership, and shaped ownership entitlements according to the characteristics and interests implicated by different resources. And important thing about the Roman jurists is that actually the Roman jurists didn't rely on some intuitive and abstract idea of resource, but imported into law external frames of analysis, positive, say economics, or normative, philosophy and religion. Think, for example, about the distinction between res in commercium and extra commercium. Res extra commercium may be for religious reason, sacrae religiose sante. That's a distinction, it's a taxonomy that is based on Roman religion and religious principles. Think of things that are extra commercium because of a public interest. For example, the distinction between public things and res communis. Again, res communis is initially a philosophical category, right? Or think about res mancipi and res nec mancipi. Well, today we would say that's a question of a positive economic frame of analysis. Things that are of social economic value in the early Roman agrarian economy. Or another distinction that is largely opaque to us today, that between single things, composite things, and totality of things. Single things are things that are composed with one single breath of pneuma, of the word spirit. That's a Stoic philosophical idea. So the really important aspect here is bringing external religious and philosophical frames of analysis to give content to property, into property. The Roman law of things was carried through the centuries, but it really, in the treatises of the 19th century liberal jurists, of the Romanist bourgeois jurists, it remained largely antiquarian, and it seemed to bear very little consequence on property, on dominion, on the definition of property. It was finally revamped towards the end of the 19th century, in the 20th century, by jurists such as Giurisprudenza and Pugliatti. And here I have the image, an image that I love, that is taken from Pugliatti, Property is a Tree, which to me is the best exemplification of this resource-specific approach. The idea that property is a tree, not a bundle of sticks, property is a tree with a robust trunk that symbolizes the autonomy-enhancing right to control the use of a resource for beneficial purposes. And then several branches that are resource-specific bundles of entitlements, shaped to reflect the particular characteristics and interests of different resources. So residential housing, agrarian property, mines, intellectual property, family or marital property, different coexisting property regimes differently structured. Now, I believe that this resource-specific approach is still critical today. Pugliati's tree is still critical today. It's still critical today as we face major challenges. Property law faces major challenges: stark inequality, environmental devastation, fundamental challenge with privacy and surveillance. What the way forward at a structural level is a structural transformation in the direction of predistribution, what James Mead, British economist in the 50s and 60s, described as property owning democracy and liberal socialism, and today is called predistribution. An ambitious transformative strategy that has property as its center, right? That it involves greater provision of public goods and greater transfer of income through the traditional mechanism of the welfare state, but also a more fair distribution of capital, of resources from the get-go to individuals and to collectivities. Property is crucial to each of these strategies. But we need new property tools. We need, in part, to reimagine property. And many people who are sitting in this room have done very important work to imagine these tools, right? So the work on the commons that Ugo and many of you have done, the work about decentering one idea of full ownership and focusing on a variety of modes, more limited modes of owning, Alessandra Quarta. What I want to suggest today is that this resource-specific approach based on the Roman law of things is yet another important tool. And it consists of 4 very modest propositions. Property is about structuring social relations with respect to resources. Property consists of different combinations of entitlements and disentitlements to emphasize the idea of power, property and power. The typical 4 entitlements are right to use, right to exclude, right to transfer, right to be immune from loss. The specific combination of these 4 typical entitlements and their scope needs to depend on to be resource specific, to depend on external framework of positive and normative analysis about resources. And I'm going to leave it here. Thank you so much.
Very, very interesting analysis. I have 2 points. One is more of a provocation. The other is more technical. The first is the bourgeois, the making of the modern Roman property model came with both the right and the left agreeing in confiscating the property of the church. And that was said by Antonio. So today, nobody is talking about confiscating the property of big tech, which is the universal power at this moment, and it is what is in between any serious attempt to construct society in a way that is a little bit more fair. So I think there should be some sort of claim, political, on the right and on the left, for confiscating Amazon and the big tech. And I think we should be serious about this, because otherwise all what we're talking about is not going to be without any kind of political impact. The second point is more technical, is connected with my read of Pugliati is slightly different from yours. I adore the fact that you revamped the idea of the tree, and I enjoyed very much. I think it was your Vanderbilt article, right, that came out with that some time ago. I always thought that Pugliati's work was much more, the trees were made not so much of the nature of resources, but on the legal choices about the legal regime. So in some sense, it was more about a sort of positivistic vision of how the law deals with urban properties as opposed to agrarian property, as opposed to all of those, rather than the structure of the utilities and economic utilities. So I think you're adjusting the Pugliati model and you're making it more bottom-up than it was in the Sicilian master, at least in my take.
I think I totally agree.
Okay.
Mine is a contemporary reading of Pugliati for presentist purposes.
Yeah. Okay, so we agree.
An attempt to make Pugliati relevant to today's debate.
Which I agree very much on the project. So thanks so much. I think it was a really fascinating talk, and now I think we are looking forward to Radhika. Radhika, please, you want to stand?
No, I want to...
Okay, you want to shift
switch
this?
so I
can put my slides.
Also, I have to go back in the slide chair.
Okay. Here. Let's see. Okay. Perfect. So thank you. I also want to echo Anna's thanks to the organizers of this conference, Luisa and Andrea for hosting us here, and Ugo and Mauro for inviting me, and thanks to all of you for being here. It is such a pleasure to be back in Trento, where I visited about almost 10 years ago, so it's been a while since I've been here, but it's a great pleasure to be back. And thanks to Anna and Professor Gambaro for paving the way so beautifully for what I'm going to talk about today, which is property in biomaterials. Let me start with a preface that takes us back to the origins of land ownership in the United States. I start off teaching my own property class in San Francisco with an infamous case called Johnson against Mcintosh, in which the U.S. Supreme Court, in that case, ratified the taking of land from Native Americans. And in that case, Chief Justice John Marshall said, "Conquest gives a title which the courts of the conqueror cannot deny, whatever the private and speculative opinions of individuals may be, respecting the original justice of the claim which has been successfully asserted here." Johnson articulated the discovery rule, that the discovery of the New World gave the discovering nation the exclusive right to extinguish the Indian title of occupancy, either by purchase or conquest. But this principle, of course, only thinly papered over the underlying truth, that the rapacious colonial powers were vying in a vast grab for land and territory, so they needed a principle to settle disputes among themselves over competing claims to property and sovereignty in the New World. Although the discovery principle could have been interpreted to provide some protection, limited as it were, to Native American tribes, by confirming their title of occupancy and requiring it to be extinguished only through conquest or purchase, it wasn't interpreted that way. So in a later U.S. Supreme Court case called Teton Indians against the United States, the Supreme Court rejected a claim by Alaska Native tribes against the U.S. government for compensation for the taking of millions of acres of their land, even though the Alaska Natives had never been conquered, nor had the U.S. government purchased their land. Instead, the Alaska Natives actually welcomed white settlers with open arms. But in the Teton case, the Supreme Court said, quote, "Every American schoolboy knows that the savage tribes of this continent were deprived of their ancestral ranges by force, and that even when the Indians ceded millions of acres by treaty in return for blankets, food, and trinkets, it was not a sale, but the conqueror's will that deprived them of their land." With that preface, let us fast forward to today and modern times. In a case called Moore, against regents of the University of California, a very famous case. Almost every student of property knows this case. The California Supreme Court held that Mr. Moore, that his spleen was not his property, so that when he filed a claim for conversion against the doctor and the researcher who appropriated his diseased spleen and used it without informing him, used it to create a cell line, which ironically they called the Moe cell line, named after him. He could not proceed in his property lawsuit for conversion, even though they did say that he could proceed on his claims, his tort claims, for lack of informed consent and breach of fiduciary duty. Moore's case is reminiscent of an earlier case involving an African-American woman named Henrietta Lacks, whose cancer cells were taken without her knowledge or consent to create the first immortal cell line, which again they named the Hela line, Henrietta Lacks, after Henrietta Lacks. Hela cells were used in labs all across the world. They were even sent to the moon, and they were instrumental in the development of the polio vaccine. Yet Henrietta Lacks's immense contributions to the field of medicine were seldom acknowledged, and they were never compensated. And today, many members of her family are too poor even to afford health care. Every American schoolboy may be aware of the vast land grab that led to the formation of the United States, but very few people are aware of the biological property grab that is taking place today. The property of the future, I would argue, is not land, important and significant as that is, but intellectual capital. Yet the rush to stake claims over the new forms of biological, technological, and intellectual property is proceeding apace without proper consideration for the contributions of all of the different parties who are involved. Rights over body property are being awarded to researchers, to universities, to hospitals, and even to corporations, at the same time that courts are rejecting the claims of those who provide what they call the raw materials in the form of their own blood, tissue, cells, and organs. And the winners in the race to capture or take conquest, if you will, over these new forms of biological, technological, and intellectual property disproportionately represent the same groups who engaged in the conquest of Native Americans' land earlier, once again leaving behind the indigenous tribes, minorities, and other vulnerable groups. So bioproperty resources, I would argue, are being viewed as appropriate to capture or take conquest by the first person who puts them to productive use. Very much the same way that Professor Gambaro described with respect to the plunder, I guess that Ugo would call it, of agricultural land that happened earlier. And so, as Professor Gambaro says, attribution of ownership is often given to those who can best exploit the resource and put it to productive use and cultivate it. And this is accompanied by the Lockean idea that those who work the thing should own it. So what are we to make of this and these questions? I've studied these issues from the framework of looking at them as property or looking at them as privacy. Rebecca Skloot, the author of the book about Henrietta Lacks, The Immortal Life of Henrietta Lacks, captures the issue beautifully when she says, on the issue of body property, how you should feel about all this isn't obvious. Scientists aren't stealing your arm or some vital organ. they're just using tissue scraps that you parted with voluntarily. But still, someone is taking part of you, and people often have a strong sense of ownership when it comes to their bodies, even tiny scraps of it, especially when they hear that someone else might be making money off those scraps or using them to uncover potentially damaging information about their genes and medical histories. Property versus privacy as these contrasting frameworks. Property suggests that my body is mine, so I own it as an object of property. Property protects the autonomy of an owner, so it also implies the power to alienate body parts, to fragment them, manipulate them, and put them on the market as a form of commerce. Privacy, on the other hand, suggests that my body is mine, but I have the right to keep it private, personal, inviolate. Privacy protects the autonomy of a person, so it also captures notions of human dignity and fears that loss of privacy may lead to self-incrimination or discrimination. In terms of property rights, the law seems to suggest that individuals possess no property rights in their body parts once they've been separated from their body, because recognition of such rights would be repugnant and could restrict or inhibit research. However, researchers, hospitals, and universities have been protected and allowed to possess property rights in the biological materials that are stored in biobanks, as well as the cell lines or genetic information that's produced from them. And what about privacy rights? Physicians have been held to owe a fiduciary duty to their patients to disclose information regarding their own research and their financial interests in order to obtain informed consent for medical treatment. But researchers have been found to have no duty to the subjects of their research, and in that context, informed consent merely requires that the donation of biological materials for research be voluntary rather than coerced. It doesn't really require the provision of information about the goals of the research or the researcher's economic interests, because imposition of such duties might hinder or impede research. So, to talk a little bit about informed consent, what you might call the death of informed consent, really, and this connects very well with the theme of death of contract that Ugo was talking about earlier. Informed consent, I think, is the contractual approach to body property. There are a couple of interesting examples about informed consent in the United States. One of them involving research using blood samples taken from newborn babies without their parents' consent, and another involving informed consent and the biological materials taken from indigenous tribes. Newborn blood spots have been challenged. The ownership over newborn blood spots has been challenged. And in fact, in the US, at the time of birth, blood samples are routinely collected from newborn babies in every state, without, in many cases, in many states, without even the parents' knowledge or consent, in order to detect and treat a variety of genetic diseases. But what happened in Texas and some other states were that these blood samples, after being taken for the purposes of the prevention and treatment of disease in the newborns themselves, were stored indefinitely and then made available to others, to third parties, for research use. When in Texas, the Texas parents found out about this, they sued the state health agency for violating their rights to privacy and liberty under the Due Process Clause of the U.S. Constitution's 14th Amendment. They argued that blood spots contain deeply private medical and genetic information that was expropriated, taken without their knowledge or consent. One of these parents in the case said, quote, "The nurses asked me if they could give my son a pacifier. They asked me if they could give him formula, but no one asked me if his DNA could be stored in a state database. And so there's a photo of the baby who said, and the parent who said his government, her DNA had been taken by the government. In this litigation, a federal district court in Texas ruled that the plaintiff stated a claim and refused to dismiss their lawsuit. So in 2010, the parties reached a settlement agreement, which in fact gave Texas, the state, 70 days to destroy approximately 5 million blood samples that had been collected from newborn babies over the past 7 years. So that's a case involving the newborn blood spots. But the litigation still continues, and many states have come up with some very interesting solutions to this problem, which I'm going to talk about at the end. In response to this lawsuit, Texas enacted a new law that provided that the State Department of Health could retain the blood spots for use, but parents would have the opportunity to opt out and ensure that the children's blood samples would be destroyed if they filled out a form. So that was the close of the Texas litigation. We'll come back to this at the end. In terms of indigenous tribes, my other example that I want to talk about, the Havasupai tribe of Arizona, there was a very interesting case involving informed consent to the use of their blood. Specifically, starting in 1990, members of the tribe gave blood samples to researchers at Arizona State University in order to find out whether there was a genetic basis for what was an incredibly high rate of the diabetes disease among tribe members. But the researchers took the blood samples that had been given for the purpose of diabetes research, and they conducted other kinds of studies. Studies on schizophrenia within the tribe, the degree of inbreeding in the tribe, and the geographical origins of the tribe. And all of these studies contradicted the tribe's cultural and or their religious values. One tribe member who attended a PhD presentation at Arizona State University found out about this research. And she said, quote, "I'm not against scientific research. I just want it to be done right. They used our blood for all these studies. People got degrees and grants, and they never asked our permission." So when she found out about this research, she went back and the tribe filed a lawsuit against Arizona State University. The tribe members filed a lawsuit against ASU, contending that they gave their blood only for the purposes of diabetes research, so there was no consent to do other research. But the court ruled that there was informed consent because the tribe members signed a form granting blanket consent to donate their blood for research to study the causes of behavioral medical disorders, which the court found was broad enough to encompass all these other forms of research. So the tribe lost the informed consent legal battle, but they were ultimately vindicated morally when, in April 2010, Arizona State University agreed to a settlement, despite the legal case against them. They agreed to a settlement to remedy the wrong that was done. Because what had happened was a number of other tribes were so angered by what happened with the Havasupai in this case that they started refusing to engage in research with Arizona State University. And the university faced a huge kind of public opinion crisis, so they agreed to this settlement. ASU agreed to pay $700,000 to 41 members of the tribe and also return the remaining blood samples. And it also agreed to provide other forms of assistance to the tribe, such as scholarships and help in setting up a clinic to help deal with diabetes research. So ultimately, they won in the court of public opinion, even if they lost their lawsuit in court. But all of these developments seem to protect biological materials only in terms of privacy rights to give consent, informed consent to research, and perhaps to receive information, some information regarding the goals of the research. But the individuals who've donated biological materials or supplied them have no right to control the kinds of research that may be performed, and certainly no right to compensation or to profit from commerce in biological materials. And this raises the question, why not property rights? Why is it repugnant for individuals who donate biological materials to share in any resulting profits, when physicians, researchers, universities, and corporations are all free to reap the profits from this commerce? And wouldn't recognition of a privacy right for those who donate biological materials to receive detailed information regarding the goals of the research and to specify the kinds of research that may be performed hinder research just as much as recognition of a property right? So informed consent seems to raise, truly informed consent, seems to raise many of the same administrative issues as property rights, and yet that seems to be the framework. Why not property? Well, I think that some of the rejection of property stems from this idea that Anna sketched out earlier of Blackstonian property, as that sole and despotic dominion which one man claims and exercises over the external things of the world, to the total exclusion of the rights of any other individual in the universe. However, as Anna showed so beautifully, property rights need not be absolute, exclusive, and individual. Instead, you can think of property as a bundle of sticks or a bundle of rights. And according to Hofeldian theory, or I guess you could say the social obligation, theory of property, as Anna terms it, property is relational and conceptualized as a bundle, so it need not be all or nothing. In fact, you can have, as Anna suggests, resource-specific entitlements, and different bundles can attach to different kinds of resources. Individuals need not have every stick in the bundle with respect to every resource. They could have some of them, such as the right to possess property in the body, and the right to exclude others, but perhaps not the right to buy it, sell it, or destroy it. Moreover, the concept of property as a bundle of rights means that it's possible to disaggregate the various strands or rights in the bundle and apportion them to different parties. Hence, different sticks in the bundle with respect to biological property could be allocated to different individuals or even shared by a family, a group, or the public collectively. And I would suggest that this bundle of rights property framework provides a powerful framework that is capable of addressing many of the attributes of human biological materials. First, human biological materials are not just physical objects or things. They also incorporate information, genetic information, and property beautifully encompasses this dual character of biological materials as both tangible things and intellectual property. Moreover, biological materials may undergo many transfers and end up in the hands of those who have no connection to the original source. Property rights can provide ongoing protection because, of course, they are in rem, meaning they run with the object or thing, and are enforceable against all of the world, unlike contract rights or informed consent, which are in personam and only bind particular parties. Moreover, property provides a mechanism that is able to mediate conflicts, not just between the owner of the resource and outsiders, but also among and between multiple owners of a valuable resource. The framework of property seems perfectly designed to accommodate shared interests between and among multiple owners of a resource, because property, of course, can be shared among many owners simultaneously, and with the estate system, rights and property can be divided over time, with current interests belonging to some and future interests to others. Finally, property offers a variety of flexible forms to accommodate all of the different types of shared ownership interests, including joint tenancy, tenancy in common, the trust, partnership, corporation. So many different forms of intellectual property regimes exist as well. So, why not property? Well, I think that there's a connection, deep connection, between property and sovereignty, of course. And as Morris Cohen, the famous American legal realist, said, we must not overlook the actual fact that dominion over things is also imperium over our fellow human beings. It seems that property provides us with a more powerful framework, if property is power, than the idea that property law could be invoked over body property, I think, becomes very powerful as a regime. And in fact, the reluctance to invoke property law with respect to body property probably stems or is connected to our fears about slavery, the history of slavery, as well as the commodification of human beings. But ironically, today, the avoidance of property seems to transform subjects, human subjects, into objects that can be owned only by other people, resulting in new forms of oppression and exploitation. If we think of humans and human research subjects as autonomous individuals who should possess the power to contribute, not only to contribute their biological materials, but also the right to help to control the course of that research and to share in the resulting benefits or even profits, conferring body property might enable subjects of human research to regain power and a measure of self-sovereignty. Rebecca Lax, back to Rebecca Lax. Here it is. In Europe, if you think about body property, protecting biological materials under the rubric of privacy rather than property may be consistent with the vision here, the European vision of health, as a basic human right rather than a market commodity. But in a capitalist system like the US, where health is a commodity to be purchased on the market, it seems unfair that everyone except the individual who donates the biological materials is permitted to profit. Deborah Lax, the daughter of Henrietta Lax, points out the irony in the asymmetric altruism that enables everyone except for the individual who supplies the biological materials to own property, when she says, quote, "I always have thought it was strange. If our mother cells done so much for medicine, how come her family can't afford to see no doctors? Don't make no sense. People got rich off my mother without us even knowing about them taking her cells. Now we don't get a dime." And in fact, the experience with Henrietta Lax suggests a possible solution to this problem of lack of body property. In fact, many years after the taking of Henrietta Lax's cells, just recently, there was controversy over the Henrietta Lax human genome. Because Henrietta Lax's cells had been used to create this immortal cell line, they were out there for researchers to use and exploit. So some researchers in Europe, in fact, sequenced the genome, Henrietta Lax's genome, and then they put it on the internet for everybody to see without the knowledge or consent of her family, which in fact involved disclosure of private genetic information of the family members because of their relationship to Henrietta Lax. So there was a huge controversy over this just a few years ago. And after this controversy, the National Institute for Health established a very unique resolution to this issue. What they did is, following discussions with the family of Henrietta Lacks, the National Institute of Health reached an innovative agreement to form what they called the Hela Genome Data Access Working Group, which is composed of researchers and 2 members of Henrietta Lacks' family. This group now owns and controls access to the Hela genome, so it could be viewed as having a kind of a limited property right to shared, because of the shared genetic information, the shared nature of the genetic information. The family is now part of the working group, and they help to have some rights. In fact, the National Institute of Health requested all researchers who generate or use data from the Hela cells to include an acknowledgement of the contribution of Henrietta Lacks and the continued generosity of her family. So at least they get some kind of acknowledgement. Also, according to National Institute of Health, the relationship between researchers and participants is evolving. Seeking permission emphasizes that participants are partners, not just subjects. Thus, this plan, according to NIH, reflects a true partnership between the Lacks family and the biomedical research community. I would suggest that that development is a kind of new quasi-property, if you will, in the Lacks family with respect to the genetic data and information contained in her Hela cells. So even though their mother's cells were taken, at least the ongoing genetic information, they are now allowed some say in determining who gets access to that information and can use it for the purposes of research. So that, if you will, is one modern form of bioproperty. Another really interesting example of bioproperty is the result and outcome of the newborn blood spot issue. As I told you, Texas enacted a law that required parents or gave them the ability to opt out from providing their newborn's blood information to the state. But Michigan, in response to the same newborn blood spot issue, came up with an even more innovative solution. What happened in Michigan was in 2008, the Michigan Department of Community Health convened a roundtable of experts to discuss the newborn blood spot issue. And what they ended up doing was to create a Michigan Bio Trust for Health, pursuant to which they granted all of the citizens in the state a communal right, if you will, a biocommons, to benefit from research using what they called a valuable public resource. So today in Michigan, dried blood samples that are collected from newborn babies under a mandatory public health program are retained by the state indefinitely for research use. But under Michigan law, the Michigan Department of Health has qualified ownership over these dried blood samples. So it must act as a fiduciary and exercise control over them for the benefit of the children and the public. Accordingly, the Michigan BioTrust makes the blood samples available for research to benefit the public health, but not for research on non-medically useful cosmetic products. Moreover, the governing structure of the Michigan BioTrust includes a Community Values Advisory Board that represents the citizens of Michigan regarding the types of research that are seen as appropriate by lay people in the state. So this solution, to me, perfectly exemplifies a commons, a biocommons, if you will, in which the Michigan BioTrust imaginatively incorporates and reframes an ancient property mechanism, the trust, to provide a paradigm for a biotrust that treats the donors of biological materials not just as the objects of property law or even the subjects of human research, but rather as full-fledged partners and shareholders in the research enterprise. So that, to me, is a beautiful example of a biocommons. Even more recently, there have been some attempts to create capitalist bioproperty. In fact, George Church, who is one of the Harvard University genetics pioneers who helped to invent the CRISPR new gene editing technology, he and some others have very recently, in fact, just in 2010, created a new startup that wants to monetize people's DNA with digital currency. This is already happening. Genetics companies like Ancestry.com and 23andMe are taking people's saliva, sequencing their genomes, and they're being paid to do this by the individuals, and then they're taking the genetic information and selling it, marketing it to third parties, which is incredibly valuable. Well, what George Church in this new startup is seeking to do is to allow individuals to do that themselves and profit. So he created this startup called Nebula Genomics, which the idea is they're going to allow individuals to put their own biosamples and biomaterials out there, but collectively for research use by researchers, so that this will allow individuals to become bio-entrepreneurs, if you will, bio-capitalists who will market their own DNA and through use of the blockchain technology to protect their privacy and cryptocurrency, which is the currency in which they will get paid, they will be able to capitalize upon their own biomaterials and genetic information. So that's yet another model of what could be a bioproperty, which I think brings us really beautifully to some of the issues that Ugo wanted to discuss. So I'll end with, what of these models should we adopt, and how should we think about our biological materials if we conceptualize them as a form of property? Should we think about them in terms of biocapitalism and the blockchain and individual entrepreneurs, or should we think about it as some form of limited shared bioproperty like the Hela Genome Data Working Group or the Michigan Biotrust, which of course gives individual citizens a kind of a collective ownership or biocommons, if you will, that's administered in the public trust model. Here are some all very interesting examples of bioproperty. Thank you.
Thanks so much, Radhika. This was very, very interesting and instructive, and really shows how the distinction between the subject and the object, which is basically the foundation of positivism, the out there, the word as it is and the ought to be, are just ideological constructions that are falling apart under technological transformations today. And as lawyers, this is something that we have to deal with. We have no categories in private law that is not based on the distinction between the subject and the object, the owner and the good that is owned, the subjective element of the tort and the damage, everything. And the common core was developed 25 years ago, believing we were not positivistic because we were not using legal positivism, right? But in fact, scientifically, this is still where we were and probably where we are, and maybe we are there for a while because there are some needs to use that kind of methods. But these are all questions that have to be asked and to be discussed foundationally and also in applied ways. And perhaps now this is the time of research that requires materials, and so it's very interesting to hear talks like this that opens up really mind-blowing things that are happening, like the blockchain used for marketing your own body lines, cells. I mean, it's a very modern form of prostitution, I get, in some way, right? So it's very advanced, looks very advanced, and you're paid in cryptocurrency and all of that. So thanks so much, and now I really would like to listen what Christina has to say, and in a way we are, getting the new generation of scholars commenting on what's going on here. So thanks very much for being here, Christina, and you have the floor.
All right, fantastic. Firstly, yes, to echo everybody else, really am honored to be on this panel with people whose work I have deeply admired for so long. And also thank you so much to Ugo and Mauro for organizing and for bringing us all together. So it really is an honor, a privilege for me to share this panel. Being the last speaker of what I call the graveyard shift, which is just after lunch and just before the dinner, I recognize that it will be quite difficult to sort of keep everyone's attention. And so I see my purpose as twofold. The one being to sort of comment and sort of try draw together what everyone has said this evening, just in case concentration lapsed at any point, but I doubt that severely this evening. But also the second thing I will do is pose questions. As a young scholar, I tend to find that in the beginning of our research, we have not that many answers. And if anything, the world that we see and the realities that we face right now really just generate a number of questions. And what better opportunity than this room with this incredible panel, and also just the incredible scholarship that's in the room, to start talking about some of these very interesting realities that we face and how to move on forward from there. So I'm hoping that'll be also a good segue into the question and answer section that we'll have after I'm done. And so just to start off with the very fantastic topic around the expansion of property. And I think it's good that we started with the old guard, whose wisdom we deeply appreciate, giving us a framework, because when we start talking about the expansion of property, it becomes more and more necessary to figure out what do we understand by this? What are the principles that we're holding on to? What are the frameworks that we'll apply, as we've seen, as new forms of property are burgeoning and coming up? And so it was fundamental that we had Professor Gambaro just giving us that framework and pointing out what is important. Also appreciate Anna's work and just the phenomenal legal history that she has done with looking at the dominion, as well as how it was deterred or impacted by social function of property, but then also now proposing a different way of looking at property. And I think she touches on it in her upcoming book, the whole issues of inequality and sustainability. And I think what I gather from her talk is that those are the really two critical issues that we're facing at this point, is the issue of how sort of the latent nature of property, as we've seen it with modern dominion, is that it has this built-in fact of creating inequality, that there will be the haves and the have-nots, that it will define social structures in a certain way. And so she highlights how that's built into what we understand so far. And so inequality is almost inevitable because the system keeps replicating itself after its pattern and after its design. If I almost want to borrow from Radhika's language and say almost in its DNA, property has inequality built into it. And as a result, that is increasingly problematic in light of what we see. I think Professor Mattei talks a lot about ecological disaster that we're in. And if anyone has experienced the weather in Italy recently, I think we can maybe all agree that there's something going on with climate change, because it's increasingly colder than what I associate with the Mediterranean. I feel like I came to the Mediterranean, and now it's a myth. I was expecting it to be way warmer than what it is. And so we have issues of sustainability and this ecological disaster that we need to deal with, which I think Anna really does really well in terms of tracking how that has been playing out with the relationship between capitalism and the issues of ecological sustainability, that we are in crisis mode at this point in time. And if we understand the DNA of property to be extractive and to be depleting the resources that we have, then once again we are replicating the DNA, that we're going to keep sort of doing the exact same thing if that is the fundamental structure and framework of property as we understand it. And so this now necessitates a different way of thinking about it. And then this brings me to Radhika's presentation, which I think is absolutely phenomenal because it's showing us the reality of where we are. I really enjoy the historical conversations because it gives us perspective of how to think about things. But I think Radhika's presentation is really showing us that we are in stranger times than we like to believe. that I think in a lot of our conversations we think that it's something of the future that is still coming. The idea that you'll be able to rent out your genetic code, we think, that's something for the X-Files and science fiction movies or Marvel movies that we watch. But that is a reality of now. And so what does that mean in terms of how are we thinking about property in a way that is cognizant of the reality on the ground? That we have a property system that has been passed down, a modern property system that replicates a DNA of inequality and a lack of sustainability. We have new forms of property which are constantly developing, and law tends to find itself sort of on the back foot of that. I think you said something very interesting with the Hasuvian tribe, the Native American tribe. I think you said something along the lines of the fact that they lost their battle in court, but they won the public opinion. And I think that is sort of a failure of law in that sense, that in the courts where law is supposed to be keeping up and law is supposed to be protecting people, they lost there. And so law is sort of always on the back foot of all these new resources that are constantly being developed in the property regime. And this is something that has become critical for us now to start addressing. Otherwise, we're constantly going to be in the back foot of protecting people because we haven't quite conceptualized the necessary tools in order to resolve these sorts of disputes. And so going to this whole idea about, Anna's idea about looking at a resource-specific approach to property, and then sort of, I think you mentioned that under this paradigm that we would then need to start giving value to different resources. And as a result of the value we attribute to those different resources, that is how we'll deal with it. And I think just to link the conversation between Anna and Radhika is how do we then, so I think it's interesting, the situation with body property, how do we then start to give value to bodily property and sort of the parts or the bits of us? So how do we say that, my eggs are worth a certain amount, a sample of my DNA is worth a certain amount? And I guess maybe the first question that I've been sort of grappling with is I find a tension for me personally in the idea that that in order to protect people, in order to protect, I suppose, what you would call these new sources or these new types of property, in order to protect people, we first have to objectify them in order to protect them with the current property tools that we have. And so for me, that just seems to replicate the problem. That just seems to, if in the DNA of property as we have it, is a sense of inequality, lack of sustainability, and power asymmetry and all those various things, that the fact that we are commodifying people in order to protect them feels as though we're just sort of throwing more I don't want to say bad property. We're just throwing more problematic aspects of property at the problem and hoping for a different result, when in actual fact the latent DNA is going to keep replicating the same issue. And so I think we need to sort of start talking about is there perhaps another framework? So I think you talked about privacy, property, or another framework. And so I sort of thinking off the top of my head that perhaps that maybe we should be investigating other frameworks that might be more appropriate at protecting the interests of people within their body. I know that the US is a very different jurisdiction, and sort of thinking from a South African context, that my instinctive feeling would that would be a human dignity concern. So if we're talking in the line of, in the South African context, we have the concept of Ubuntu, which didn't make into the Constitution, but there's that sense of, it refers to a sense of humanness, relational relations between people, that we prioritize relations and community because there's an inherent value and human dignity in the person. And as a result, we protect the person, we protect the community because we value those relations among people. And so from that perspective, which I recognize is quite different from the American context, I think the clauses that might be applicable in the American context would be the 4th, 5th, and 14th that sort of gets bounced around. But from a South African perspective, I think we have the legal framework or the legal principles that infuse this idea of relationality, that we emphasize a person's human dignity, and that's what we protect. And so in instances where a person's DNA has been sold or misappropriated or something has happened, we would rather say, well, let's ask what is the human dignity of the tribe that we want to protect, and we will protect their human dignity. And so it wouldn't be a loss in court. In fact, the Constitutional Court would be required to uphold the dignity of these people who did not provide consent, who were, there was a massive power asymmetry, lack of information, they didn't understand. I think most of them were quite uneducated. And so that would be a human dignity conversation. And I think in different jurisdictions, I'm sure in the German and etc., that might be a different perspective on human dignity as well. But I think from a South African perspective, I would have gone down a constitutional human dignity approach as opposed to going straight to more property law principles, which are flawed in order to protect the people. And so maybe there is a different framework depending on the jurisdiction, and that we can borrow from jurisdictions in sort of this incredible comparative context to bring different ideas as how to protect people in those instances. So that's my sort of general feeling with regards to how do we protect people without objectifying them first in order to protect them, that there should be some form of inherent dignity, inherent value that we protect and we prioritize before market considerations. So that's that. And I think just then to be quite contentious and also provoking, as Ugo often likes to put it, I would like to maybe ask Anna, and maybe if you could maybe speak into Radhika's presentation around how do you value the resource of the human body? Where do we start in that valuing process? So if we're going to now say, well, we've acknowledged that perhaps that we shouldn't be following the DNA of what has been problematic so far, and we now want to focus on this more this newer approach that looks at the value of the resource, how do we start then valuing the human body? How do we value bits of the human body? How do we sort of put a value into that if we're going to talk about a property lens looking at what's happening? And I think that's important because of the tension we're in, that we're talking about ways of reconceptualizing property that will take time. I think you talk about it with the historical narrative, that it was actually a very subtle approach in which it was very sort of subtly built up that the modern sense of dominion became so powerful as it is because of the wide acceptance that it found through various audiences. And it was quite a slow, subtle process. And so so maybe then realistically our ideas are going to probably take a lot more time than we would like to hope. And while we're in this tension of there is a current property paradigm that is dominant at the moment, and you're now proposing something that will shift from that, how would you propose that we start to give value to resources in a different way that takes into consideration the fact that we probably still have a long way to go? So even as the future generation, I'm also equally as nervous about the future and not entirely sure where to go from here. So I'm hoping that we can have some lively and interesting discussions about that. All right, thank you.
I don't know what time is it, but no, it's just 5 o'clock. So I guess what we should do is there has been some thoughts that Christina had put on the table, and we should react briefly to those, all of us, and to reflect a little bit each other presentations for just a few minutes. I have just one thought that I put on the table for discussion. I have the chance of spending some time in the heart of of San Francisco, of the Silicon Valley, and the culture of the Silicon Valley became very pervasive also in Berkeley in the last few years. So I had this recent episode that I reported of a next door neighbor of mine who is a hot guy in the Silicon Valley fame, very famous guy who has now a company who does robots and stuff like that. So one day he flies a very, very tiny drone in my background, and that looked like a cunning bird. And then he would send me some pictures of my kitchen taken from his hummingbird drone, and then he said, "Oh, Ugo, we play tennis a couple of times a week together there." So he said, "Ugo, look how cool the pictures taken from my new drone." And I said, "That's great, but there might be some privacy issues there, right?" I thought it was like, and maybe some property issues too, And he looked at me and he said, "You think I'm worried about that?" I said, "Well, no, I just wonder." And he said, "Well, you know what I'm worried about?" He said, "I said, what are you worried about?" He said, "I'm worried about the if the Koreans are gonna do it faster than me, okay? Because if I can come up with this viable thing before the Koreans do it, and he was competing on the global market, then I make so much money that I can take care of all the legal issues when they will appear. Okay, so I will have so much money to pay for all your law students and your salaries and all of that I don't worry now about that. And that really made me think about this sort of kind of attitude that is becoming very pervasive, which is better to say sorry than to ask permission, in a way, okay? So you just the property rule idea in Calabrese framework, right? That you can transfer the entitlement, but you need to get consent, so you have to ask permission, as opposed to the liability rule, the ex post, that you kind of, you don't ask permission, you just flap the guy, and then you compensate for whatever you've done before, right? With some sort, and the ex ante versus ex post vision of law and how law functions and all of that. And it seems to me that talking about resource-specific property rules, when we get to the frontier of the internet, let me use this idea, this notion where capitalism is kind of moving now in those kind of transactions that are mediated by platforms and so on and so forth, that's much more a word of possession than a word of property. Seems to me that is much more a word of de facto relationship. And also what radical, and this kind of gives me a different sense also in front of the issues like the ones of radical, because these guys that are taking the blood of the kids and are collecting it and kind of making something useful, arguably, for society out of that blood, why the parents of the kids should have an entitlement to say you don't do that out of some sort of anthropocentric, individualistic vision of property, privacy, which is very much kind of part of the modern narrative, right? I own my body, like a little bit Lockean kind of thing, because I own myself, therefore then I own all what I do with my hands. It's very primitive, seems to me, this whole vision, right? It's very primitive, this vision that, it's primitive that the children of that poor lady cannot afford healthcare, but that it's primitive, the United States, as far as their healthcare system, has nothing to do with what we are talking about here. What we're talking about here has to do whether the way to entitle someone to healthcare must be to claim that your mother provided the cells for a line of research on which you should have some sort of strange ex-ante entitlement based on this primitive Lockean's vision of the individual-centric society, right? So, in a world in which, in fact, the reason why we're talking about these things is not that we're talking about property. These people just do it, have the technology of doing it. It's like with the data, like with the data footprint, right? I leave this data. I have no idea how much this data are worth. I have no idea what these data are to begin with. We have no idea as lawyers how they are actually constructed and produced and how the surveillance capitalism works and how much they worth. But if you have the Google algorithm, those data are very, very valuable to you. And the question is, should I say this is my data and therefore I should claim it as property? Or we should say there is a common kind of thing, which is the production of social knowledge, and no asshole, out there in Cupertino should be able to profit from all of that by controlling it just because he owns the algorithms, right? So and he's just working on possession. He's just the only one who is able to possess those data. Because how do you possess your data? You mean your cell phone knows more about you than you know about yourself, and you don't possess your data. You don't possess more data than what you remember. Yet, your data footprint is huge. There are so many more things about Ugo out there in the world than the ones that Ugo actually knows about himself. And there is no way that I can deal with that, but someone is capable of possessing it. And property at this point would become something that you use against someone who is actually able to possess it in order to say, you cannot possess it because I own it, even if I have no value out of it whatsoever. But also he will say, I have ownership, I acquired ownership, and so we use this magic word of ownership that legitimizes what is de facto a power relationship, right? And so this is, I don't know what this is, but that's what it came in my mind out of these thoughts. So thank you, I'm done. Yes, sure.
Well, Ugo, I think that it's possible to reason in another way. That is to say, in front of the cases that has been mentioned here, probably neither possession nor property nor ownership are the category that are useful. I think that we have to reason in the direction of a claim of unjust enrichment. Probably is the best legal tool in order to solve the problem. I know that in the American tradition, unjust enrichment is a category not so used even in Europe. But probably is the best legal tool that we can use to solve this matter, because indeed to reason in terms of property bring to the unpalatable solution to say that for instance, a child or a patient was given his own consent to the use of a sample of his blood, etc., and really no interest at all to in his DNA, especially when the sample is anonymous, so there is no problem of personal information, it's just a problem of scientific information. They can claim some property right, that is to exclude that my DNA can be used for a different purpose for which I have given my consent. Even if the different line of research, so the different purpose, is extremely useful for the advancement of medicine, cure, etc. Doesn't make any sense to imagine that a stupid guy can stop a line of research that maybe can bring a discovery that is helpful for everybody. This is an allocation of right that doesn't make any sense. So it can be different if somebody can, for commercial use, etc., can enrich himself using Henrietta blood. But in that case, unjust enrichment could be the more correct claim, not to stop, not to forbid the other and scientists and researchers to conduct their research, but to share the commercial or monetary benefit of the research that is possible.
Yeah, so then we go to the trust model that was taken to her. To share with whom? Only with, it's basically, who are you disgorging the unjustified enrichment to? That's the point, especially when the unjustified enrichment is huge, right? You create a foundation, you create a trust for research purposes. I mean, it needs to be...
Some of these lawsuits actually do involve claims of unjust enrichment. So in the United States, unjust enrichment was actually argued in many of these cases. And in some of the cases, the courts were willing to allow a claim for unjust enrichment, but then a settlement happened. In some of the other cases, they said, no, there's no unjust enrichment claim. But I'd like to respond to a couple of the interesting comments. So Christina suggests that instead of property, we should think about perhaps dignity or the notion of Ubuntu in the South African constitution. early in my career, when I was thinking about property versus privacy frameworks, I very much leaned against property for exactly the reasons that Christina was arguing, that it seems problematic in its inherent DNA. The property really privileges certain kinds of utilitarian, capitalistic, extractive uses over others and seems to privilege certain parties over others. But on the other hand, it seems to me now, after working in this area and studying for more years than I would like to admit, I am slowly and reluctantly coming to the conclusion that when you don't allow individuals to have property, but in a situation where other people who gain possession and put to productive or utilitarian uses or granted rights, it ends up in a more exploitative result than, so that maybe in order to protect individuals, we need to adopt some form of basic individual property in the people who are the subjects of this kind of research. It seems to me that through experience that otherwise everybody else is granted rights except for the most vulnerable parties. So property can be a form of protection. And property doesn't necessitate only certain forms of capitalistic, extractive market property. And I think that's the lesson that Anna is trying to suggest.
I think, I just want to reinforce everything you said and also answer. Your comments were fabulous. Thank you so much and so well taken. I share your preoccupation that with property expanding to new resources that were not initially considered property. This morning, Professor Van Erp, algorithmic property, data and information, and now Radica, biomaterials. By expanding property to new resources, yes, there is the risk that because property has this sort of extractive element and this inequality built in, we would only be replicating, as you nicely put it, bad properties. We would have many new bad properties. That's a concern I share. And that's why I think we need to reimagine property. And the resource-specific approach is one of the lines along which we need to reimagine property. I really think that we need to change the framework completely and move to a framework where there was one owner, one type of resource, is a material physical thing, one fixed bundle comprising all the sticks, and one value, one bundle serving one value, autonomy, the will of the individual, to a very different model, where there are many resources, many owners. We have to identify who should be an owner, who are the stakeholders here, who has an interest that needs protection. Not one bundle, but different bundles with different shapes, different scope. And finally, not one value, autonomy, but many values, dignity, equitable access to fundamental resources, community, self-authorship, and a variety of other values. Now, I really liked your point, your final point. This is going to take so long. You seem so pessimistic. Romanist bourgeois property, as I described it, was a process that really took 2 centuries. It was developed over a long period of time. It started with dominium. It ended up with the social function, and the two are easily coexisting. If we want to develop a new framework, reimagine the way we're going to think about property, that's going to take a long time. It's not going to happen immediately, and now we have all these practical questions to solve. There, I'm more optimistic than you. I'm more optimistic because I think we don't need to invent anything from scratch. A lot of what we need is already there. So property as a relation among persons regarding a resource, well, that's the Hoffeldian intuition that we are very familiar with. And for us continental Europeans, it was already an idea very clear in dominium divisum, which I think is a useful analytical category. Resources, well, the Roman law of things. It has been around for centuries. It's only a matter of foregrounding it again. The commons, The idea of res communis has been around forever. It's only a matter of recentering it. Possession. Possession may be a way to go, maybe a useful way of decentering the idea of the one fixed bundle giving virtually absolute control, and instead opening up to a variety of modes of owning and using things. Again, possession has been there since ever. It has been, at least in Europe, at least since Savigny's famous treatise on possession. So these elements are all around, and it's just a matter of foregrounding them and revamping.
Yeah, one thing that it comes, I totally buy the analysis. A few years ago, I tried to develop the idea of generative property as opposed to extractive property, to try to say, well, property is not necessarily only about extraction and exclusion. You have to switch this off. And it seems to me, however, that there is something that is in the nature of property at the center of the private law building, which shares some of the fundamental structure of the nature of law itself. Because also law in general. What's that?
Yeah, it's the blue thing.
What's the blue thing? I hate this. Okay, so. No, okay, let me do that. So, I mean, property shares some parts of what the law shares. And on the one hand is the Janus phase, right? On the one hand, the law serves the interest of the stronger, has always been like that, and so sets on the side of the big guys. So if you try to take away property from very extractive uses like, again, just not to be obsessed, like Amazon, for example, and you try to expropriate that on some claim, you're going to find, scores of lawyers that are going to protect that taking. It's almost impossible to be done within a constituted legal system as we have globally today. So the law is strong on the side of the strong guy, but on the other hand is also a shield in the hands of the weak guy, and so it cuts two ways. There's no question about that. When we challenge the Marxian analysis of property just as a way in which a class oppresses the other, it's easy to say, well, look, there are moments in which property, in which law is emancipatory. Like, slaves were ultimately released from slave status, and women ended up voting, and all these kind of things are through the law. So law cuts the way, and property also seems to me that cuts the way. So so that's when you try to reimagine property to do projects like this, we have to keep this very clear and understand in this sort of nature specific who actually then has the entitlement, and there is where I believe possession is quite important in terms of there are certain things that now you can possess only if you have a certain concentration of capital. It's like when we were years ago, we were discussing about financial property. Right? Financial property is so much connected with the structure of financial institutions, the access to information that you don't have, and so you need a social class basically that develops out there that deals with it, of specialists of finance that work in their field and make their own professional projects. Today is happening with the technologists, and this is kind of part of the broader problem. Should I open the floor for some more questions, if there are any? Please, Filippo. Now there is an issue with the mic, I guess.
Should I come down?
Yes. Why don't you do that? Or at least you approach.
Either the chairs are becoming smaller and smaller, or I'm becoming bigger and bigger. We can. No, I thought that the conversation I heard was indeed very interesting. I wanted to address a question primarily to Professor Rao, or rather a comment. I found myself when I listened to your presentation automatically comparing the narrative you were presenting with another narrative that I'm being indirectly working recently because my doctoral student Saki Bailey is finishing her thesis in which she explores ways of re-embedding certain types of resources or certain type of social values rather in the market. And the resource she's working with is housing. So she's essentially exploring how you can use commons tools in order to dampen or try to at least make speculation in the housing market less harmful to weaker parties. And she's based essentially in California, where the problem is, and she's working also with law centers addressing that issue. And if you listen to that narrative, the narrative is the following. Well, essentially, if you buy a home or you buy some property in California, you have bought it, like, say, 30 years ago, you have done nothing to improve that property, and by pure chance, by pure luck, now you end up being a millionaire because of market forces, market speculation. And that is considered unjust because by sheer luck, you are essentially partaking in gathering resources by putting some weaker parties in a difficult position, people who wants to live in the cities in order to work there, for instance. The narrative you're presenting is, of course, based on a completely different resource, but almost the opposite. Well, I am in the lucky position of having a specific type of DNA, and now I should partake in the profits of that DNA. I was listening, for instance, to a guy who has the very peculiar genetic configuration that makes him immune to HIV. And he's, of course, his DNA is extremely valuable for research. And in a world where that DNA becomes a part of a market, he could easily be a millionaire simply by a random combination of, genetics, RNA, and DNA. And my point is simply this, that it seems to me that the only strong structural difference between these two situations, or the big similarity between these situations, between these two narratives, is the will to protect what is perceived in a certain circumstance as the weaker party. But with very different logics and very different tools. And I wonder, the big difference seems to be that when it comes to the bodily parts, the DNA and so on, what you really want to achieve is essentially privacy. So while I understand the sexiness, to go via property, because property carries a certain charisma in our legal culture, it seems to me to be a detour, even considering the advantages that you mentioned as, the right in rem and so on and so forth. It seems to me that the suggestion is take a big detour, essentially kidnapping the sexiness, the charisma of property in the liberal legal culture that we... and that's, I admit it freely, is probably a very European perspective, but that's my 2 cents. Thank you.
Thank you. Very interesting. Saki Veli actually was one of my property students. So the idea of property and inequality, I totally agree with you that it seems very random and fortuitous that somebody who's sitting on a house which has accumulated in value due to no efforts or work by themselves shouldn't necessarily profit. But in our capitalist system, we allow people to profit from extraction of value in land or minerals, that you just happen to buy land under which there are valuable minerals or resources, and you are able to extract that profit. So what seems unfair here is that in the genetic market, individuals aren't allowed to kind of get any of the value of their own biological resources, but third parties, others who put them to utilitarian uses, do get those profits, even if it's completely random and fortuitous, that they've invested work and so forth. So I would be happy with redistributing those resources, or even considering them to be a collective pool and having them shared among all of the individuals who put into the pool, that you should get some benefits. But what seems unfair is to say that those resources are in some sense unowned and up for grabs by the capitalists who turn them to market utilitarian uses, but they're unownable by the people who actually, generated the resources. That seems the unfairness. And I guess what I'm suggesting is I agree with you that property seems an unlovely way to go about it, and privacy seems so much more affirming of dignity and self-worth. But the problem is, in a system where property is so strong, privacy protections end up being no protection at all. That's what I've learned from experience. And so I feel like if you protect it, the human body, under the rubric of privacy or informed consent, essentially what ends up happening is that there's no protection. And let me give you an example. Professor Gambaro talks about, individuals shouldn't be able to obstruct worthy research. And so individuals shouldn't have a stake. We should look at other tools. But Iceland, for example, essentially adopted that approach. And it said that all of the medical records and genetic and other information were owned collectively by the government. And they then sold it to a private corporation. Because they said, you individuals don't own it. These are collective resources that are possessed by the state. So we can sell it without your consent to this corporation and get whatever benefits. It was supposed to be some idea of providing drugs without, that were patented, maybe that were going to result free or at reduced levels. This was in fact contested by an individual who said that her father's medical and genetic records involved her own private information. And the Icelandic court in that case said that there was a problem with privacy rights. But it's very rare that privacy actually ends up succeeding in the face of a property claim. And so I feel like we should use the tool of property, but as Anna suggests, reformulate and revitalize, which is why I was trying to give you alternate property models. I think the Michigan Biotrust is a form really of property. It takes the ancient property trust mechanism and imagines it as a kind of a biocommons. Similarly, the Hela Genome Working Group is a kind of a shared property right, if you will. Some property scholars are talking about joint tenancy or even tenancy by the entirety as property models for DNA ownership, because DNA is inevitably shared among family members. So maybe all of the family has a stake and some kind of a dignitary or privacy right that can be protected through the rubric of property. But if we deny property protection to the individuals and allow property to everybody else, then what ends up is a total asymmetry. And in that asymmetric system, some people, it's a replication of what I suggested is the earlier land grab, where the new biological property grab, some people are grabbing all of the entitlements and others are left with nothing.
Is that there is not just just a second, Francis. There is not just either property or state sovereignty. Actually, the problem you're pointing out with Iceland is that then if the state sells some public property, they can do it and nobody's entitled to challenge in court. That's why we argue that the commons are needed as a category that gets some of those constitutional protection that property has and we don't have against privatization. But it seems to me that in restructuring this conversation about property, however, we must take into consideration the other thing that Gambaro said opening the remarks that were kind of forgotten, which is the time dimension. Because why it seems like something you say, oh, the guy was very lucky, he got a very good DNA. What about the other guy who was very lucky, is called Rockefeller, and has inherited that property? You know, if we start getting into the idea whether something is deserved or not deserved as a reason to have property, then we have to expand that line of conversation also to the law of succession. And the law of succession is really called into question by Antonio's first remark of saying, well, you know, the idea of imagining property forever, what it means. I mean, I'm going to die anyway, But then, someone is going to be lucky enough to be my son or my grandson, and this is going to create, a continuous accumulation of property among certain lines. And the United States, from this point of view, has been extremely successful in reproducing, whatever the American Revolution was against in a very short period of time. That is a huge concentration of capital in the hands of a very few people.
Can I add something in response to Filippo?
Yeah.
So your analogy between these two different resources, housing in the Bay Area and biomaterials, only reinforced my idea that about the promise of the resource-specific approach, and that the reasons why we structure entitlements in a certain way has to come from outside law, has to come from external frameworks. All we can say internally about property is that property is about the allocation, production and allocation of resources, and it consists typically of a set of 4 typical entitlements that are differently packaged. But how we package them, how we shape them, that has to come from outside. That has to be informed by external frames. It has to be informed by what, for example, economists tell us about housing, what theorists of distributive justice tell us about the fundamental need to housing, urban development specialists tell us. And for biomedical research, it has to come from scientists, from bioethicists, again from theorists of distributive justice. But there's a limit to how much we can do with a purely internalist idea of property, I think.
Yeah, I wonder why you haven't mentioned the political choices. I mean, it looks very technical. I mean,
each of those are ultimately political choices.
So basically, it's the political process that gives the concept. There was Franz who has a question.
Well, just a small remark following up on your presentation. It seems to me that you're saying we must protect the people who are going to be the object of the research. We must entitle them to some form of property right. How about denying property rights in the first place to the people who grab the information or the data? I mean, in my view, Mr. Zuckerberg is a thief. He's a total thief. But it does not come to anybody's mind in the US to challenge the fact that he has illegitimate property, that he has acquired things that do not belong to him. So it seems to me that we need indeed to take care of the people whose information is sucked away by thieves, but we also need to mark boundaries about the right to steal. And it seems to me that maybe I'm naive or I've lost all sense of, it seems to me that the Moore case in Europe would not have been decided as it was in California, just simply because you cannot operate or use information without the person's consent. And one concept that is, of course, hard to translate, which refers to personality rights, is a concept that I haven't heard float around. I've heard privacy, but privacy transformed into property, essentially. That's where we are going, to entitle people. How about going back to rights that are not in the market and that cannot be the object of property, but still are in people's control? I'm losing my sense of the intervention. But what about the Moore case? Would it not be decided differently in other jurisdictions than in the US? And how about this fetish of the property for the person who collects and grabs? You used the word grab. I was intrigued. Thank you.
Yeah, I really do think that we're having a biological property grab, actually. And that's why I started off with the land grab, because it really seems to me that what's happening today is very much a replication of that in these new areas. And I agree with you. Why should it be property for these other people? But I guess I've become a pragmatist, or I've given in. It seems impossible that property will not be protected. And so the only way to apply some corrective is to kind of have proliferation of more property rights rather than arguments against. And so Zuckerberg and his ownership of the data, there have been feeble efforts in the United States. In Europe, European countries have enacted data protection laws. But in the United States, Vermont, for example, tried to stop medical pharmacies from selling data about consumers, consumer data regarding drugs, in order to protect the consumers from what was happening, which was the pharmaceutical companies were buying this data from the pharmacies and then using it to directly target and market their drugs in a much more precise way. So Vermont, the state, in the United States said that we are going to prohibit the selling of this commercial data by the pharmacy. And what happened was this was challenged as a violation of free speech. And the U.S. Supreme Court said that it was, in fact, a violation of free speech rights. So when the state tries to legislate and take away property in the data or information, the court responds by saying that that's constitutionally protected. So I am so pessimistic about the ability to take away property rights from those who are going to extract productive utilitarian value from them, that I guess my response is to suggest the proliferation of more property rights in the individuals, because the only corrective to the theft, the grab on the part of the powerful, is to give property rights to the powerless.
Okay, I guess that it's 10 minutes before 6, and I would like to have a few minutes for Christine Mack to explain, which is the from Intersentia, which is the new publisher of the Common Core series, to give a very short and presentation about what is going to happen in the publishing line of our work, collective effort. And you will understand the reason why we are shifting toward Intersentia right now. So please, Christine, welcome to Trento. Thank you.
Well, thank you very much. Right, so it turned out today that it would be a good idea that I took this opportunity to address all of you. So I quickly thought about how do I do this best, and I think it's basically 3 points that I would like to do. I would like to explain who I am, I would like to explain who Intersentia is, and then I think I would like to explain on how we think to get involved with the Common Core project. So, just a few words about myself. I'm Ann-Christine Mark-Scherpe. I'm a lawyer by education. I studied in Germany and in New Zealand. Then I moved to the UK to become a publisher. My task was to build up Intersentia's English language office, which I did in Cambridge. We are growing very nicely, and we are now running all of the English Intersentia titles from the UK office. I've also been made a really fancy title. It's called a CPO, a Chief Publishing Officer for Lefebvre-Sarrut, because Intersentia, since 2018, is now also a member of Lefebvre-Sarrut, a publishing group based in France. And you probably know us better by companies like Giffre Editore in Italy, SDU in the Netherlands, El Derecho in Spain. So there's a variety of nationally operating publishing houses. Intersentia now belongs to that very same group, and we are the English language output. So my role involves making sure that we are building our new titles for the next year's catalogs, but I'm also involved in actively commissioning projects. And so it was also myself that took on the conversation with Mauro and Ugo about the possibility of bringing the Common Core project to Intersentia. So how do I think we can get involved? And I think there are 2 points. One point, and I just like to emphasize these two, pretty sure there are many more. The first one is author support. And the second is how to continue the availability of the research of the Common Core project through publishing. So just a few words on the author support. Our publishing ethos at Intersentia is that we are publishing cooperatively. That means we publish with and for our authors. So what does this mean in practice, and what could that mean in this particular context? Just by listening and observing today, I realized there are a few questions that came up repeatedly, like what is the length of the contributions? What is the question? There were questions about format, questions about structure, questions about timing. And I think that I could help with all of these questions when they arise, just by contacting me, and then we have a discussion and a dialogue about it. But also, what are other aspects? I think that when we are getting in a cooperative mind and we are starting to publish together, then we can help from a much, much earlier point in time. So to really organize and manage a multi-author project in the most efficient way. And I apologize here because clearly my German roots come through talking about the efficiency aspect. But what do I mean by efficiency? I do not mean efficiency or most efficient for the publisher, but I mean most efficient for you as authors, as editors, and also for the publisher. So I think by just talking at a much earlier point of time, we can find a good solution. It may not be all the time, but I think we can do it, and I believe this for 3 reasons. First, Intersentia is a publishing house specialized in comparative law. The second one is, I was, during my law degree, a student assistant at the Max Planck Institute in Hamburg, and I had to adjust formatting for a 1,000-page book, and preferably I don't have to do that again. And the next one is, while I'm not an academic, I'm married to one, so I do understand the issues that arise in the publishing business. What could that mean? Just a few more examples. Before you are trying to adjust something in your contribution or across contributions, maybe in a quick telephone call we can actually establish that this is something that we would do at the publishing side anyway, so it will save you free time. Or you've come across something that you really dislike but you aren't quite sure about how you could approach it. Maybe we have done it before and actually we can share that experience. But just sort of leaving the author service side for a little bit more, how else do we get involved in this particular project? And I mentioned continued availability of the series. So on the one hand side, I mean the traditional publishing model. We are producing a book in print and in e-publications at the same time. We're doing marketing, but modern marketing, including discoverability online. And of course, we have a distribution set up. Now, my distribution is set up across the world, so I do print across the world. I have stock across the world, so I don't fly it around from one location with a plane. But what we've also discussed with, discussed between the 3 of us, Maru, Ugo, and myself, is what can we do about the series in the future? And this is where we spoke about how can we best use the digital content that is created through the Common Core projects. And what do I mean by that? Really making it accessible through new media or publishing approaches alongside the traditional form. We all need more time. There is time pressure, there is information overflow. So how can we ensure that we can use the the sort of technological development actually for us? This is something that we have been working on at Intersentia. It's not something that I share, but I would like to share that we are thinking about this. So I think this brings me basically to the end. I'm very glad that I was here today. I do have a much better understanding of the Common Core project, how it's working, how the projects are chosen, and then how they are actually born. So I do hope that we will be working together. Please do never hesitate to actually write an email to me, find me on LinkedIn, or communicate in any way by the phone. Most efficient sometimes, I think. And yeah, I'm looking forward to a cooperation. Thank you.
Very nice. So it's 6 o'clock. We had a very lovely afternoon. Thank you very much to all the panelists, to all of you for being here. We are going to meet at 8 o'clock for dinner at the Terra Mia, right? Which is the former Chiesa for those of you who were in Trento 25 years ago. Okay, everybody.
Yeah, we have the map.
Okay, thank you. Bye-bye.
Tu sei al Grand Hotel Trento?
Sì, tu?